Excellent. Hello. My name is Ben Johnson at the American Immigration Lawyers Association. I'm very proud to be here and to be part of this panel. As in one of the many ways, I am no Stephen Yale-Lair. I'm pretty sure nobody on this panel is going to spend their time thanking me for my great moderating skills and organization. So thank you to the panel for putting up with the black hole that is my email inbox. As she's like, Ben, what role do you play? Hello, who are you? So I think we're going to have a really good panel, mostly because we have some really good people, not because of me. So I want to just quickly say, and I know there will be time to say other things, but you know what an honor it is to be here and to be able to be on these panels. You know, when you look at the list of panels, you know, your first thought is always, you know who'd be great on that panel? It's Juan Osuna. It is just structured very well to talk about the things that he was passionate about and very good at. I had the great honor to meet him a long time ago, oddly enough, introduced, I think, by David Neal in the INS reorganization days after 9/11. And you know, it was sort of a random conversation. We were thinking about if INS was going to get reorganized. You know, was this an opportunity maybe to think about doing, you know, EOIR? There was a court reform opportunity in here that we could create. Naively, we thought maybe there was a chance for that. Maybe downscaling the objective, thinking about a commission instead of Article 1. Like, what could you do? And David was at that time, I think, at Sam Brownback's office. I knew David. Maybe I had heard of Juan. But you know, he brings in this guy to help think about these things in a smart way, and I'll never forget thinking, well, who the hell is this guy, and where has he been all my life here in Washington D.C.? He really had a wonderful ability to be smart, not just in terms of the substance of what he was talking about, but to be smart in thinking about what was achievable. How to understand, let's set a goal of getting here, but let's understand how do we get there, navigating the people and the ideas that are part of the ecosystem that we have to live in. So, and it wasn't just, you know, pragmatism. It was that. I think maybe in this environment that word is, you know, taken on some negative connotations. It felt different than that. It felt like intellectual empathy. It took an understanding of where people were and how we needed to get them comfortable with the ideas that were being explored. And I think because of that experience, Juan was always the first person I would reach out to when I felt like we had a crazy good idea that needed to be just a good idea. How do you take the crazy out of this idea? And Juan was always a really good source of information, of being able to bounce ideas off of. And you could do it, you know, back in that world where we didn't circle our wagons and feel paranoid about talking, you know, even when he was in government, you know, at the BIA, he was always somebody that was willing to pick up the phone and really talk about interesting ideas and more than willing to tell me in his polite, funny way that, okay, so that's crazy, but here's what I think you know, we might be able to think about. So I miss that in him every day. So you have a great panel of people here to talk about this question of due process, how the system works, legal representation, and the role of it. I encourage you to read these pretty impressive bios. We have with us Alyssa Currier, who's a legal advisor for Human Trafficking Institute's initiative within Uganda's Office of Public Prosecutions. I find that very interesting as a part of your bio. Former attorney at UNHCR, too, so well-versed in these issues. Lindsay Nash, a clinical assistant professor of law at Benjamin Cardozo School of Law. She was a Skadden Fellow at ACLU Immigrants' Rights Project, which, you know, brought us Lucas Gutentag, so take what she says with a grain of salt, obviously. Senior attorney, Victoria Nielsen, senior attorney at Catholic Legal Immigration Network, working on their Defending Vulnerable Population project. And of course, Michele Pistone, who's a professor at law at Villanova University School of Law, where she founded the school's in-house clinical program. So we thought that it might be good to try to figure out, to try to define the problem, you know, to change up what we just talked about 5 seconds ago and actually have you start off. We want to figure out what is the size of the problem we're talking about when we talk about legal representation and due process. And, we had been thinking about this a lot, mostly because we had left Alyssa off of our email chain very much in the context of representation, access to a lawyer. And then once Alyssa got onto the email chain, we realized, well, it's worth talking a little bit about how the system is engineered to make that incredibly, incredibly challenging. So I guess in terms of thinking about the size and scope of this problem, let's start from the systemic perspective and talk about how, even on our best day, the system is engineered to try to push people through either so fast or to tip the scales so far against them in their aloneness, right, even before they get a chance to talk to a lawyer, that it makes the challenge of getting them lawyers even more difficult. And I know you've been working and interested on a lot of those kinds of issues. So why don't you start us off about just some of the ways, as the previous panel talked about, how the system has its thumb on the scale in terms of being able to deliver due process.
All right, sorry. I never got the opportunity to meet Juan Osuna, but based on what I know of his work and what everyone has told me about him and what we've heard here today, I know that he has made an immeasurable and lasting positive impact on this field, and it's an honor for me to be here speaking on this panel. So thank you for inviting me and listening to me here today. I'm going to talk just a little bit about summary removal procedures, which we heard a little bit about from Andrew on the previous panel. Just going to go a little bit more in depth about the nuts and the bolts, because I think even for those of us that are immigration attorneys and spend a lot of time working on these issues, it's kind of ambiguous and opaque what goes on in a lot of these removals, and that's because they usually take place behind closed doors and we don't get to see what goes on, and they take place, like Ben said, very rapidly. So I think I'll start with expedited removal. It's the most infamous one. Everyone here knows about it, and so I won't go into a ton of detail, but basically expedited removal is what happens when someone is inadmissible, a migrant is inadmissible or deemed to be inadmissible, either arriving or within 100 miles of an international border inside the United States and can't prove that they've been here for 14 days. And what happens is they don't have to go before an immigration judge. They don't have to have an evidentiary hearing. They can just be expeditiously removed from the United States. And this is, of course, very concerning for a variety of reasons that I'm sure most of you know even more about than I do. But interestingly enough, it's potentially the most protective of the 4 summary removal procedures that exist. And that's because asylum is still an option in expedited removal proceedings. And not only that, immigration officials are actually required to inform folks in expedited removal proceedings of their right to seek asylum. And whether this happens or not is a completely different story, but at least in theory, they are required to do that. In contrast, in the other summary removal procedures, they're not required to do that. A second summary removal procedure is stipulated removal. These days, this is not actually very much of a problem because due to litigation back in 2010 and some other developments, stipulated removals are down quite a bit and hardly ever used. But basically, that was a process that peaked around 2006, and it was just an immigrant in removal proceedings could stipulate to their own removal, which in theory sounds fine. You should be allowed to say, I'd rather be removed than stay in detention and wait for my hearing. But in practice, there were, of course, a lot of due process concerns with that. And so what would actually happen in practice is that folks would be approached by immigration officials with a stipulated removal request and asked to stipulate to their own removal when maybe they didn't even speak the language that the request was written in. Officials could approach children, they could approach mentally disabled folks, and so it just wasn't, it didn't offer very many protections. And judges recognized that, and that was one of the factors that's led to its decline. A third summary removal procedure that is still in use, although there's no public statistics on how often it is used, is administrative removal. And that applies to migrants who have been convicted of what is determined to be an ag fel or a crime involving moral turpitude. And as anyone who practices immigration knows, that determination is incredibly difficult to make. I think it was Justice Alito who said that that determination is incredibly difficult even for an attorney to make. And what's happening at the border is these are folks who are not attorneys. These are immigration officials that are not trained in how to do the legal analysis, but they're determining that these migrants have been convicted of AGFELs or CIMTs, and then that therefore puts them in administrative removal proceedings where they are not allowed to seek asylum, and they can be removed from the country without a hearing before an immigration judge or even the signature of an immigration judge on the removal order. But what my colleague and I, who were doing some research into this, found to be the most disturbing of the summary removal procedures is the fourth one, which is reinstatement of removal. And this accounted for the most of all the summary removal procedures in 2016, most of them were reinstatement of removal. And what happens is an individual can be removed from the United States based on a removal order that they got a long time ago. There's no statute of limitations on this. So you can be removed from the country based on a removal order from 20 years ago. You don't even have to know that you had a removal order. You could have been removed in absentia for a variety of reasons that anyone who practices immigration law knows. Maybe you didn't receive the NTA. Maybe you didn't understand the language of the NTA and didn't know you were supposed to appear in immigration court. But if you were removed in absentia, you can still have that removal order reinstated and removed from the country. And the most concerning thing about reinstatement of removal is it doesn't just apply when you've had a fair hearing before an immigration judge before and you've had your claim heard and it's been decided fairly. It also applies to removal orders that were issued through expedited removal proceedings or stipulated removal proceedings or administrative removal proceedings. So you could have had an administrative removal order from an immigration official who made a faulty determination on your AGFEL or CIMT because they're not trained in that. And now what's happening is that due process violation is being compounded a second time because you're being ordered removed a second time based on that initial due process shortcoming. So these are the four summary removal procedures where these folks are usually not represented. And this is just kind of a window into, this is the majority of people who are being removed from the United States. These very concerning abridged due process procedures, or abridged process procedures, and most of them do not have representation. So that's kind of, I guess, the setting in which we are looking at the need for legal representation. It's not just an immigration court. It's also definitely in these four different processes that often take place where no one else is even watching.
So I know several years, maybe it's many, I'm old, so it's hard to know the difference between those words anymore. But there was a study done by the Commission on Religious Freedom, I believe, that looked at the expedited removal proceedings, and even with evaluators in the room with these folks, like taking notes on how the process worked, the study found that don't remember the exact statistics, but in an alarming number of cases and percentage of cases, they never even gave the basic warning of, oh, by the way, if you have a fear of return, then you would be entitled to at least some review of this particular fear. Have there been any other studies since then that looked at this? Has the agency responded at all? What kinds of protections are there in place in this environment that at least the minimal rights that are available to them are made known or followed through? Any sense of that?
No, I don't believe that was the last study that's been done on that. And unfortunately, there are not safeguards in place. And that's why it's so concerning, because that's happening in expedited removal where it is required. But in the majority of summary removal procedures, it's not even required that they be even informed of their right to seek asylum or any other form of protection, because in most other proceedings, they're not allowed to seek asylum. So no, unfortunately, there aren't safeguards there, and that's a concern.
So let's talk a little bit about the question of legal representation, right? We've got a system that where the house they built doesn't have certain features to it, doesn't have independent judges. It's got pathways around it, so lots and lots of people don't even get into this house of justice that they created. And yet those people who do find themselves in this court setting, in a detained setting, many of them don't have any idea what's happening, and they have very, very limited access to some sort of an advocate, some sort of a guide that can tell them what's going to happen to them and what happens. What we do know about all of these failings of the system is that in every setting, somebody has a lawyer, and that's the government. They always get a lawyer in these settings. Let's talk about how often does the respondent, how often does the immigrant in this context get a lawyer? So Lindsay or Victoria, let's talk a little bit about the size of the problem of not having a lawyer, this access to justice issue.
Sure, and first I want to thank Don and Rachel for organizing, and Ben. I also didn't know Juan, but I entered the field at a time when he was already in government, and I was working on legal representation and access to counsel issues, and at the time I understood EOIR to be sort of an engaged and helpful partner, and I understood only later that that was really directly because of his influence. So I'm happy to be here. So we have some numbers nationally, and I think it helps to put a little bit of context to them. Nationally, about 40% of people are not represented. That's a higher rate of representation than in past years, but in raw numbers, there are more people who are unrepresented than in previous years for a variety of factors. So it's still, a significant problem, even though the rates of representation are increasing. And I think just to sort of give it even a little bit more context, we looked at this issue in New York in particular in 2010, 2011. And you can see that even there in an urban area that's progressive, that is really committed to protecting immigrant community members in a variety of ways, the crisis in representation really specifically impacted people who were detained. So even in New York, where there's a relatively large number of resources, 60% of people in the detained court were unrepresented, which I think shows the scope of the problem generally, but specifically for people who are detained. We didn't look at the numbers elsewhere, but I have to imagine they were significantly worse. That's just the rate of people who are unrepresented, and I think at that time, there was a lot of questions about how much that actually mattered. Some people had this idea that, it feels like it matters. It feels like people should get a lawyer. It's not fair to put them against a trained government prosecutor without them even understanding, but it wasn't entirely clear what the actual impact would be if that same category of people got a lawyer. But since that time, there's been a number of studies that have really made the impact of having an attorney stark. And so in that same study in New York, in an urban area, you could see that people who are detained and didn't have a lawyer, or people who were not detained and had a lawyer, succeeded about 74% of the time. People who were detained and didn't have a lawyer succeeded about 3 to 4% of the time. And so that was the first time that we could really quantify the impact of counsel for people who are facing removal in terms of kind of concrete outcomes in their cases. Since then, there's been a number of other studies that have really confirmed this. National studies showing the rate of success is about 5.5 times greater if you have an attorney. Your rate of success in bond proceedings is about 3.5 times greater. And so across the board in a variety of areas, we're seeing really just how significant having counsel is. The last thing I want to mention is a piece of this that hasn't really been as discussed, mostly I think because it's hard to quantify. But the benefits of having a counsel system, or having a system in which there are large amounts of counsel, is not just beneficial for win rates, but we're seeing that as really beneficial for sort of judicializing the immigration court as a whole. Having people in there has allowed, in courts that have large numbers of people who are actually represented, has allowed those attorneys to push back on ICE policies, to appeal more issues, to really bring issues up in a way that has been significant for the courts where we have large numbers of people represented. And so that's another piece of having counsel, that's another piece of how having counsel in there really bridges the access to justice gap, even for people who may not be represented.
If I could just add one thing to that. I mean, I think one of the things to me that's been most shocking about what we're seeing under this administration is the vilification of lawyers. And I mean, certainly, if we're talking about Juan Osuna's legacy, certainly his commitment to due process and the belief that there should be due process in the courts is something which I think we've seen abandoned. And I think it's, you know, it's been shocking to hear the former Attorney General of the United States, you know, talk about dirty immigration lawyers and make it sound like anybody who's been counseled by an attorney about what the credible fear process is has somehow been, you know, coached to game the system. And I think that, you know, in terms of access to counsel, I mean, we've seen the money from the legal orientation program pulled and then returned, but I think it's up in the air for the future. And in fact, the government sort of recently put out a report saying that maybe the LOP program is not cost effective. And I mean, Lindsay's talking about how the system as a whole, you know, how even those immigrants who are not themselves represented are beneficiaries when there is representation because the lawyers can sort of push back against unlawful practices. I think in the past, the government has at least paid lip service to the fact that it's more efficient even for the immigration court itself and for judges to have a trained attorney representing the respondent who can, you know, narrow the arguments and therefore presumably make the cases move more efficiently than a judge who has an obligation to sort of question an unrepresented person about what forms of relief they might be eligible for. But it seems pretty clear that what we're seeing now is just a drive to remove the most number of people at the fastest rate possible, and that lack of access to counsel is sort of a driver of some of the policies of the new administration.
So I know we're going to talk a little bit more about some of the programs and ideas that are out there to try to lean into this, to bridge this access to justice gap. But let's stay with this thought a little bit longer in terms of, like, so what's driving this? Is this there aren't enough immigration lawyers? Is this they're not affordable? Is this to what degree does the government, does the agency actively thwarting, not only systemically by creating laws and policies that prevent them from getting a lawyer, but are there other strategies? Is this geography? Are there some places that have it and others don't? I know that's a lot in that multiple choice question. Let's talk about that. Either Michele or Victoria, we can stick with you and think about it in the context of what's driving this huge problem.
I mean, I can start and would be happy to have others jump in. You know, so in a general study about immigrant representation by Lindsay, I think this was only looking at data up through 2012. At that point, 87% of respondents in New York City had counsel, whereas in Atlanta and Charlotte, only 47% had counsel, and that's not even talking about sort of detained versus non-detained. You know, I think there's a bit of a snowball effect. I mean, there was a great article that was written a couple of years ago by an attorney in Atlanta explaining why she could no longer be an immigration attorney because it was so demoralizing to lose all the time and feel like she actually wasn't even helping her clients. So, I mean, I do think that there's, you know, if you practice in New York, at least up until this point, I think attorneys feel like if they have a colorable case and really put their best arguments together, they have a decent chance of winning. I think if you're, you know, practicing in a court like Atlanta, where the win rate is something like 3%, it's hard to attract attorneys who really want to practice there because, you know, if you're taking someone's money to represent them and you basically have to say the odds of us winning are almost zero, or even if you're, you know, being paid by a nonprofit, it's very emotionally draining. So I do, you know, I think that there's that level of geographic difficulty and, you know, and then as we anticipate detention growing around the country in more remote locations and tent cities in the middle of nowhere in Texas. Just getting attorneys to those places, I think, is going to be extraordinarily difficult. And I think they're, I don't know if I would say that it's by design, but I would say that it's not. I don't think that that's an issue that is troubling to the current administration.
So I'll pick up on that, but before I do, I just want to talk for a minute about Juan, because I met Juan in 1996 when I was the legal director at Human Rights First. And he published my first article when he was at Interpreter Releases. Phil Schrag and I had just worked on EOIR, and we decided that we wanted to write an article that would give guidance to the government on what the proposed regs on the one-year deadline and expedited removal might look like. And Juan agreed to publish it. And so that led to a long-standing friendship and relationship with him. But he really was instrumental in kind of my becoming an academic and a scholar in this field. So I really, I pay a lot of tribute to him because of that. So let me pick up on what Victoria said and Ben said, and I think it's really a combination of everything, right? So it's the geographic problem. I think it's the affordability problem. I think it's not enough immigration lawyers. I'm a law professor, so I keep track of that. And I just want to say that, when I started teaching at Georgetown's Immigration Asylum Clinic in 1997 or 98, I went to a clinical conference. And there were 6 other people we broke up into little groups, and we had these working groups on different areas of practice in clinical education. And my group was the smallest. We were 6 people sitting around a table. And now when I go to the annual clinical conference, we're such a big group of people that it's like 2 or 3 rooms. And so in terms of working to increase the number of immigration lawyers, there has been a big effort. If you think of the pipeline, law schools are a really important part of that pipeline. And so to the extent that any of you are adjunct professors or involved in teaching about immigration law, I really, or if you're not and you have access to a law school, I would really encourage you to think about becoming even an adjunct professor who could talk about immigration law, because it really is that thing that sparks people to want to do immigration. And then there was also a recent article in Time magazine that reports about how there's a growing interest among law students to study immigration law. So that, I think, is another kind of push in this pipeline of getting more representation, just generally more people interested in providing services to immigrants. But I do think that, that cost, affordability is a really big issue. And, sitting from this place of being in a law school, it's hard to say this, but I think that law schools themselves are part of that access to justice problem, just because legal education is so expensive. And it really, frankly, prices so many people out of the market to provide low-cost legal services. Because, we all need to pay our bills, right? We all need to pay back the debt that we incur when we go into institutions of higher learning. And to the extent that legal education is, $150,000 investment for a lot of people, it makes it really hard for them to then be able to serve low-income people in the ecosystem. So I do think that that the affordability kind of relates to the cost of legal education. I think also there's some inefficiencies just in the provision of legal services to immigrants, and there's ways that maybe we can think as a community about how to use technology or how to kind of understand the system of providing legal education and think about whether there are any ways where we can intervene and create processes maybe that make the system more efficient. So Richard Susskind is a famous British lawyer who talks, his most provocative, the title of his most provocative book was The End of Lawyers. And it talks about how because of technology, right, well, because of technology, that there's a movement from a bespoke provision of services, which is very individualistic. So think about someone who goes and gets a suit made for them to fit their body. That's the bespoke model. And that's really the model that we have in the provision of legal services. But what he's predicting is that as technology becomes available, that some part of the provision of legal services will become customized, standardized, and even commoditized, he suggests. And if you think about LegalZoom, you see a little bit of that already, right? So you see things within the legal services process that can be done by non-lawyers. And I think what we might think of as a community are there any technologies that we might be able to develop to make the practice of law from the lawyer's perspective a little more efficient, to think about the pain points that the lawyer experiences. And is there a way, like as a community, to create technologies that might help to make it more efficient? And then I think, again, the geography is a big issue too. Like I spoke to someone who said that in legal services, like there are some organizations in Louisiana, for example, that have open slots for lawyers, but they can't, low cost, where it's pro bono lawyers, but they can't convince people to move and work in a rural area in Louisiana, for example. So I think the geography issue is a big part of it too.
So let's stick with you then, Michele, though, for a minute then, and talk about, like, so what we've described is this incredibly huge problem with enormous consequences to the people that are trying to navigate their way through this system. If you don't have a lawyer, you're far less likely, if you're even lucky enough to be in a part of the system that gives you access to a lawyer, at least pretends to give you access to a lawyer, you're far more likely to lose your case than win your case. And geography and affordability, all of those things taking place and making this problem even bigger and more difficult to deal with. I guess the question is, so what are you seeing on the ground that to you feels like creative and innovative way to do these issues? I'll call out Karen Lucas in the selfless plug for the moderator's involvement with this. We put together an immigration justice campaign with the American Immigration Council, and Karen drew the short straw, and she's the director of it. And it really is about thinking about how do we get to scale on some of these issues? How do we get representation at a scalable level in the places where they're most likely to be, which is remote and undesirable as locations for people to be for any length of time. We started off doing that in Dilley, Texas, where Jean Butterfield also spent more days than she probably cares to admit, helping us figure out how do we do family representation in Dilley, Texas, which is as remote as you can possibly be. So remote that the only Mexican food they have there is bad Mexican food, which I didn't think was possible in Texas. That's how remote it is. And the ability to get people in there for longer than 6 months to work in a clinical program is just grueling and difficult. Karen's done wonderful work. If you're interested in some of those ideas, I encourage you to talk to her about that. But I'm interested to hear from all of you. What are you seeing that feels transformative, possible, making dents at getting to scale? Tell me what the world looks like from where you sit. I know you're working on some things at Villanova, so let's start there.
So, and I want to connect with you, Karen. So I'm actually thinking about whether we can use online educational technology to train up a cohort of accredited representatives to fill the gap. So, taking so I'm a clinical professor. I've taught immigration law for 20 years. And now what I want to do is take everything that I've learned in that context and make it available and accessible to accredited representatives so that we could really kind of bulk up that part of the market and create a pipeline for people to be able to provide low-cost legal services. So I'm fortunate because Villanova has given me a leave this year to try to figure out whether this is possible. and start like kind of trying to use scalable online technologies to create a program to train accredited representatives.
And if I could
And you're doing
jump in there,
Clinic,
because so Clinic is doing something like that, and as with, so I mean, Clinic is the Catholic Legal Immigration Network. We basically provide training and technical assistance to over 330 nonprofits around the country in over 47, no, not over, in 47 states. And one thing that we've begun in the last couple of years is to try to train partially accredited representatives to become fully accredited representatives. So by the end of this year, we will have conducted trainings for about 110 people in that category. And it begins with a technology component where they have to complete online coursework. And then we have a sort of 3-day intensive trial skills training. And so far, about a third of the people who we've trained have applied for full accreditation. I mean, I think one of the challenges with expanding access to counsel, whether it's with accredited reps or with pro bono lawyers or with new lawyers, is really the mentoring. I think organizations like Clinic and many other nonprofits have great training materials that can get people sort of over the first hump, but I think the second hump really is somebody wants to talk strategy and somebody wants their papers read before they submit them, which they should, and that's what's really labor intensive. So I think that is a stumbling block for some, expansion to counsel. I mean, we are doing that for our relatively small cohort of people who are training in this way, but I do, I think that's an issue. A couple other ways that Clinic specifically is involved in, filling counsel gaps. I mean, one is our Board of Immigration Appeals pro bono project. I think, one of the easier ways to provide representation remotely is at the appellate stage. So we've had a great deal of success actually working hand in hand with OLAP to screen cases and place cases primarily for unrepresented detained people with counsel. Of course, most of the time when we're successful, we get remands. So that creates its own issue of then actually finding counsel once the case gets remanded. But at least sometimes there's some constraints put on the immigration judge by the BIA. And also in working with the Asylum Advocacy Project, we've been working on remote motions to reopen in absentia orders where, again, that's a way that attorneys can, work on labor-intensive cases without having to physically appear in, immigration court in Houston and try to remove these in absentia orders. And I do think that's such an important issue, not just for the individuals who are being assisted by having their cases reopened and getting a day in court, but I think that the in absentia orders has been set up as such a boogeyman by the current administration that like, oh, we can't let asylum seekers in the country. Nobody goes to court, and it's just this back door to illegal immigration when, Alyssa was talking about expedited removal before, and I'm sure, most of the folks in this room know that to even figure out where and when your court date is, that can be challenging for attorneys. And,
Especially when they're just making that day up.
When they make that day up, right, they put it at midnight on a Saturday night. And, for people who don't have English language proficiency and might have limited education to sort of understand that even after they've been interviewed for 3 hours by an asylum officer and potentially been in front of an immigration judge and are now checking in monthly with another person from the government, that somehow the responsibility is still on them to call a number on the phone and do a change of venue motion to get a case moved is, it's absurd to think that these, the fact that people are getting removal orders is because they're, fraudsters, to use the language of our former Attorney General. So those are, a couple of areas where I think remote representation can really make a big difference.
Lindsay and Alyssa?
Yeah, I think one of the things that I think can make a really big difference is what we've called the movement for universal representation, which is sort of like a public defender type system of appointed counsel for people who are facing removal. And it's a different kind of provision of counsel than many places have, and certainly than many places had before this model was created, because a lot of the past representation, understandably, was focused on cases where it seemed like the person had a decent chance of success, where there were some sympathetic factors, and it seemed like that was a good expenditure of resources. Universal representation is merits blind, and so there's no initial assessment of the merits, and it's this idea that everyone should get an attorney regardless of what their case looks like at the outset. And I think this is actually one of the areas of due process and immigration that actually is something that is a success right now. The first project like this started in New York, coming out of some of the studies that I was talking about in 2013 as a very small pilot project, and has expanded across New York State for people who are detained. And it's really expanded throughout the nation with the help of community advocates in different cities and the Vera Institute to sort of set up these universal representation sites. And I think the good thing that we're seeing here is it's not just in areas that you might expect. So typically progressive cities where they might be trying to protect immigrant communities or maybe stand up to some of the things that we're seeing right now. But it's also happening in areas that I never would have expected that are not sort of on that traditional radar. And so I think that there's a lot of hope here for what could be and sort of expansion. There are some obstacles, and so this is very much, I think, a work in progress, particularly as a national effort. Most of these, well, really all of these sites are funded in part by the locality, so the funding jurisdiction. They're funded in part by philanthropic funding. They have a lot of different actors coming in to talk about what the system should look like, who it should serve. And there's a lot of local concerns, as you can imagine. And so each of these systems is a little bit different. And it's kind of like this cooperative patchwork right now. And so I think the thing that is really good is that there's now emerging different kinds of variations to make these sites work for different geographic areas and different political constituencies. Mm-hmm. The thing that I think needs a little bit of sort of watching and fine tuning is, because there's so many different actors coming in, there's also a threat of dilution of some of the sort of core principles. There's some challenges to expanding it outside the non-detained context. And I haven't heard of any that have sort of dived into summary removal proceedings. So I think that there's a lot of opportunity there for expansion. But I think there's also a lot of thinking to be done about sort of how we expand it in a way that actually is logistically feasible and economically feasible. And you know, how do you do it in a way where the public defender style system in immigration doesn't suffer from some of the criticisms that have been made about the public defender style system in the criminal context? We can see some of the criticisms that there are right now, and I think the good thing is that these systems right now are quite robust, and so trying to really hold that line, I think, is going to be something that will be important for whether or not it's actually a success going forward.
I would also add on to that something to watch for with the universal representation movement, which is great, but something to watch for is the programs don't have carve-outs for certain folks. There are some of them that don't extend to those with certain crimes, and those folks can have real claims for protection as well, so we want to make sure that type of representation is available to everyone. And there's also geographic restrictions on some that make it ambiguous who is going to be represented under which city's programs. And so just some areas to watch for in an otherwise really exciting movement. I did also want to add one challenge that wasn't mentioned during the previous question. One thing is, even when you get an attorney down to a remote detention center, sometimes there's challenges getting into them and being able to even meet with your client. So a firm might fly a pro bono attorney down there and then just to have them turned around and sent right back, which can be really discouraging, not just for that case, but for the entire pro bono program at firms and at public interest organizations. So one model that is really exciting that at least one firm is working on is, I'm sure some of you have heard of the Laredo project. which is basically a firm just adopting Laredo and going down and saying, we're going to screen everyone, all the women and children's claims, and take on everyone that we find to be credible. And that allows for kind of a relationship to be built between the officials at a certain detention center, so that those kinds of issues when you are flying in folks, it doesn't happen where then you're turned around for no reason or denied access, because you have that relationship built. And although this type of representation isn't going to be as scalable as some because of the resource intensiveness of it, it definitely can be scaled among other firms. So that's something to be looking for.
If I could just pile on the challenges. They're a little easier than the solutions. I think another challenge is detainee transfers. And, one of the sort of ironies of progressive localities trying to end contracts with ICE is that that can lead to people actually being removed, not only from visitation with their family, but from counsel. So like in Hudson County, New Jersey, where everybody who's detained there has access to counsel through the Knife Up program that Lindsay was just talking about. There's this sort of strange battle going on between, the sort of more, I wouldn't say more, I don't know, the non-legal activists who are saying, we're a progressive community in New Jersey, we don't want ICE contracting with our local jail. And then the attorneys who are going to lose the ability to provide representation, because obviously ICE isn't just letting those folks out. They're going to get moved to a place where all these geographic challenges are in place. I don't know if we're ready to move to solutions yet, but one thing that one solution potentially, even though it sounds backward, for progressive communities is for them to actually enter into these contracts. So in the Albany County Jail, the Albany Law School has developed this program where they've actually been recent border crossers are being housed at the Albany County Jail, and through both Albany law students and New York City pro bono attorneys, both from the nonprofit and the law firm community, have basically been able to screen everybody there and prep them for CFIs. And they're having like 80% success rates on their CFIs. And that's basically happening because there's this very progressive sheriff who said, you know what, these folks are going to get detained somewhere. Best that they come here where they'll be treated well, and we will make certain that they get access to counsel. And, I went up there to do screening, and it was like, between that and any other jail I've ever set foot in, from the person who like took my ID, who was like friendly and polite, to, the guard who was calling down the, calling in the detainees, who was friendly and polite, not just to the lawyers, but to the detainees. It was really eye-opening. So I do think that there's, that's something to think about, that the people who are running the jails don't have to be our adversaries.
Well, I wanted to jump in terms of a challenge that I think we've been thinking about and wrestling with, and I think it speaks to some of what we've been trying to talk about here, which is, the problem is resources and volunteers and availability and affordability, but the problem is also systemic, that, it's only on a good day that you're a volunteer or a lawyer is able to go in and represent somebody, and it's only on a really good day that they have a meaningful shot at true due process and true justice. And it seems to me those things need to not be stovepiped. The idea of reform and the idea of representation and advocacy have to be merged. What we found when we were doing the Dilly project was, as people would go down there, it was a transformative experience for them, and many of them never having been in immigration court, or their immigration experience was doing an asylum application, which, even though a lot of the cases we were seeing at Dilly and other detention facilities involved asylum, it was in a very different setting than where oftentimes big firms and other volunteers find themselves. And what we found was these aha moments with people who had been in the legal community in other areas, and they say, like, does this happen every day in immigration court, where the judge turns off the recording and just starts talking about things that seem, crazy? Does this happen in immigration court every day, where the rules of evidence seem to like just flow based on what makes most sense for the prosecutor, not necessarily for the defense. Like those moments of engagement, I don't think we take enough advantage of in saying, yes, I want you to be a volunteer. I want you to be part of representing somebody, but I then need you to be part of an advocate for making this system work better. And I also think that we haven't done a good enough job of figuring out how do we not just leverage big firms for the for that asylum case experience, but how do we convince them to do more of the systemic litigation work that has to happen in that context, that isn't always as sexy or productive, or it certainly can be a very long slog. But it just seems to me we have to begin to meld all of those levers, not deal with them as stovepipes, but to bring everybody in to understand that no one of these solutions is going to really solve the problem. It's only when we combine all of them together that we have much of a shot at leaning against this this system that I think is so stacked against us. So maybe we got a couple more minutes before we invite other people to be part of it. Let me do the cheesy thing and say, so let me hand you a magic wand and say that you get to change things irrespective of the political environment. Let's not talk about what's feasible. Let's not talk about incremental change. What, from your perspective, would be truly transformative? What is the kind of advocacy or vision that we would want to invite some of these volunteers or people who don't know the world that we live in every day? What's the vision that we want to help them to see, or the goal that we want to make them, to recruit them to be part of? So what part of the immigration system do you think that, and how would you go about changing the world the way that you see it in a dramatic, visionary way?
Well, I potentially have tunnel vision right now because of what I've been really looking into recently, but I think just to kind of reiterate what I said in the very beginning, if I could change any one thing at this moment, it would be to not allow reinstatement of removal at all, but at least not allow it for those removal orders that were already ordered through summary removal procedures, which many of them were. And then simultaneously, asylum would be an option for everyone in every type of removal, because circumstances can change and mistakes can be made the first time around, and there's just no set of circumstances in which someone should not be able to claim asylum, and that's in line with international obligations and also U.S. domestic law applying those obligations. So that's what I would change.
Lindsay?
So I think the last panel made a good argument for changing the substantive laws, and I think that's what we need, and I don't have anything really more to add to that. But in the context of legal representation in particular, I really think it's all about funding. I think you will get people to places where it is less favorable to work if you have sufficient funding. I think, working in a law school, we have tons of students who really love doing this work and are very excited to be able to do it. There are more jobs now than in the past, at least in the New York area where I am, but it's still hard to get a good job doing this. And I think that, we also get calls from attorneys at firms all the time who are pouring tons of resource into these cases and to talk about how much they love working on these cases. If we had a large number of lawyers who were that well resourced litigating these cases, I think it would look like a very different picture. And so I think, just sufficient resources like that for doing this kind of work would really make a huge change.
I think from a lot of the numbers that we've talked about with different reports, like the overriding theme is that people who are detained, and particularly detained in remote locations, find it the most difficult to get counsel and to win their cases. And to the extent that detention is not supposed to be punitive, but to make sure that people appear for their court dates, I would end detention. I think whenever we write comments and things, everyone always cites to that one report about how 90% of people who had this intensive case management check-in system with nonprofits actually did appear in their court dates. And I think, this is the magic wand. It's not what I'm expecting to happen in the current climate, but it does seem like if the whole mindset was shifted away from detention and toward just giving the resources so that people make their court appearances, then we would have a positive snowball effect where people would be more likely to have counsel, and the more likely people are to have counsel, the less likely they are to not appear in court.
So I agree with everyone, everything that everyone said. I would eliminate all those expedited summary procedures. I would also love the idea of a universal representation model. I think what I would add to the list, and of course detention, I wrote 20 years ago that we should end detention, and unfortunately we're not moving in that direction. But I'm really interested in design thinking and user-centered design. And I think my goal, one idea that I would have is like to bring in a firm like IDEO, get them to talk to the lawyers who are not embedded in the immigration, the lawyers who are embedded as well, but the lawyers who are not embedded, who have like a bird's eye view of all the misfunction, all the problems in this system, and then kind of from the beginning, like design a new system that's user-centered and that understands how a case proceeds through the system and where are all the places where we can take advantage of inefficiency, reduce redundancies, create efficiencies, and just create a system that is more transparent and more focused on the user being the lawyer and also the client.
All right, so I'm going to invite, we were depending on you all being part of this conversation these last 15 minutes or so, but I'll offer while you plan your questions and comments, I'll offer my visionary goal, which is, I think, part incremental, but part aspirational, and a nod to some of the last conversations I had with Juan were about, affirming a right to counsel for an obvious subset of people who in the system, even if the law gets better, even if they end up going through the system, they're never going to be able to navigate the system their own. A right to counsel for children, those folks that are mentally impaired or unable to represent themselves. I think if we could begin to rally around something transformative like that, acknowledging that that you really have no shot. For this subset of people, have no shot unless they've got a lawyer, I think begins to change the conversation, and it allows us to begin to test the theory of efficiencies and effectiveness and the role of counsel. I think that feels to me like an important baby step to take. And again, I remember having several conversations with Juan about that, in part because of a lawsuit that we had filed asserting a right to counsel. So that would, I think, my starting point. That would be the vision I'd invite people in who aren't part of it on a day-to-day basis to say, for God's sakes, we could at least do that, right? Anyway, so questions, comments, ideas?
So I understand that 85% of the immigrants who are detained in private prisons. I was wondering if you could comment on the impact of private prisons on the due process.
That's a huge question. Because talking about access issues, they can often operate on a different set of rules. It's supposed to be uniform. It's not. You run into a lot of. We know that in our dealings with those private prisons, you run into a lot of. Oh, that's not us. That's the government. Government say, well, that's not us. That's the contractor. So the classic government salute is, I didn't do it. They did it. That's part of that problem.
I also would just look at that as a political problem. I think toward the end of the Obama administration, Attorney General Holder was saying that he was going to pull out of private prisons in the criminal context, and Hillary Clinton as a candidate was saying that she was looking at pulling out of private prisons in the immigration context. And the more that private prisons are making money off of detaining immigrants, and the more that they're giving that money to political candidates, the less incentive those politicians, once elected, have to eliminate detention. So, I think that is a huge problem, which I think just comes down to electoral politics.
Yeah, question.
My name is Suzanne Martin. I'm from Annapolis, Maryland. We started a group. We're just a bunch of volunteers. We have about 200 volunteers. And we noticed the exact same thing that you guys are all talking about. And so we just started a fund about 5 months ago. We've raised $32,000. and we're doling out $2,000 per immigrant. And I was wondering, is this happening in other cities? You know, we in Annapolis are so outraged about what's happening that we as private citizens have stood up and just started raising money without any county funds. We have a Republican, well, it's now flipped, but Anne Arundel County was pretty conservative. So we just took it upon ourselves to start raising money. But what's happening is we are spending it as soon as it's coming in. So the need is so huge. We're now doing fundraisers like every 4 months just to keep this going. And I was wondering if this is happening in other cities, or how could I encourage other cities to do this?
And is this, this money is raised and spent on, is it like bond issues? Is it getting people out of custody? Is it representation issues? Tell me what's the...
No, these are, well, I'd say 60% of the cases are children who are just, they have their master of calendar hearings, they need legal representation, they have a hearing in the future, so they're not detained. We would gladly help someone get representation if they're detained, but our problem is we just haven't had anyone yet come to us who's been detained who needs legal representation.
And it's a group of non-lawyers.
We are completely non-lawyers. We've put together a group of attorneys in Anne Arundel County that we trust. Some are in Baltimore, some are in DC, that we've, started helping to pay. And I was just wondering if this is happening, or how could I encourage other cities, private individuals to do this?
So I don't know of any other programs like this, but it's amazing. And I think we need, as a community, to figure out how to elevate that message, because I think you can be a model for, there are so many passionate people out there that want to do something, but they don't know what to do.
They don't know how to do it.
And they don't know how to do it. And I think
Right.
what you've done is a great example of what people can do. And if we can just figure out ways to elevate it and get the word out, that would be amazing.
Yeah, I mean, we've seen some fundraising efforts emerge. There was a very famous Facebook fundraising effort started out as we want to raise $2,000 for somebody to get them out on bond, and $20 million later, there's a big pile of money there to figure out how to get a lot more people access to bond. So there is a lot of energy that's out there, and I think we all need to think more about how do we both capitalize on that energy, but then also how do you direct it? Because one of the challenges I've seen in an environment where a lot more people than ever before are paying attention to this issue is that, again, they're running into the same systemic thing. I never forget, I got a call from the executive director of the Trial Lawyers Association in the middle of the Muslim ban, and she said to me, my people are ready to go. They're outraged by this Muslim ban. Tell me what airports to go down so we can start representing people. And it's that moment where you're like, where are you going to represent them? There is no representation happening there, right? And so oftentimes what I think we have to figure out is that the challenge that we run into isn't always a challenge of enthusiasm. It's a challenge of maintaining that enthusiasm when they run into the brick wall that is this system. So I think those of us who are involved in these conversations have to be talking to each other about what are we doing, how do we cross-pollinate ideas, but also how do we figure out to create places and areas for people outside to plug in and be more systematic about where do we direct ideas and resources so that it doesn't feel so impenetrable when somebody with a lot of enthusiasm, just runs into this sense of, oh, this is hopeless. Why am I going to do that, right? So that's what I think we run into more than resources and enthusiasm, is the sense of hopelessness that quickly sets in when you run into an intractable system.
I'm Melissa Crow from the Southern Poverty Law Center, and we actually have a number of representation programs in remote locations around the country where we provide counsel to detained immigrants, and we work in partnership with the Immigrant Justice Campaign and a number of other groups. On the private prison issue, I just want to flag that the fact that ICE contracts with private prison companies does not absolve them of responsibility for certain standards that they themselves have promulgated or other obligations under the Constitution or the Immigration Nationality Act. And I want to go back to a point that Alyssa made earlier about even when people have counsel, sometimes they can't get into facilities. At some of our facilities, one in particular in Louisiana, there are 1,600 beds. And before we started litigating, there was one attorney room. And there were rules like you could only call your client for 20 minutes before the line got cut. So we do have a pending lawsuit challenging these restrictions on access to counsel in a number of the facilities where we operate. The suit is against ICE, and we're keeping our fingers crossed that the result is a good one. Thanks.
Hey, Anna Gallagher.
Hi, Ben Johnson. Hi, folks. My name is Anna Gallagher. I'm with Maggio and Cater, and I wanted to follow up what Suzanne said and just a little history. Suzanne and her group are marvelous. I met them maybe a year and a half ago when I went in the pouring rain to visit and speak to their church, and I think it's a Universalist church. Oh, I'm a Catholic. I get that mixed up. So a United Church of Christ. And it was amazing because I went to speak to them. They had asked me to come to speak about a particular family I've been representing for years on a low bono and a pro bono basis. And the church wanted to become involved. They wanted to understand the issues more. And it rose around the whole sanctuary movement when all the sanctuary stuff was happening right after the elections. And I went, and I'll never forget, Suzanne came over, kneeled down, looked at me and said, I've never worked in immigration. I don't speak Spanish. And I need you to tell me how I can help. Right? And that's how this started. So I was thinking, I think, Ben, when you were saying this, or someone was saying about how Juan worked holistically, or somebody before, maybe it was Steve, the holistic approach, and how do we as lawyers, and Michele, you're talking about design, stepping back, how do we as lawyers get out of our lawyer mindset? Because the truth is, as soon as I look at a case, I'm looking at the law aspect, right? And I'm not looking at the holistic needs of the client. I'm looking about how I get the file, all of those issues. And how can we work with them? And even before we all leave this room today, for someone to talk to her, or is there a funder? Are there community development resources? Is there a funder that would sit down and talk to Suzanne or her group? Is there a way to create a program, technology, where other groups around the country will say, well, we want to do this. How do we get involved when we don't know anything? Where do we start? What are ideas? Who can we connect to? Because I think that's really important, especially given the needs. Because this group does much more than, they try to find lawyers for people, they drive them places, they help with all the challenges that impede access to legal representation and full development of cases. So I just wanted to say that holistically, if anybody has ideas for Suzanne or, just wanted to promote that. Thank you, folks.
Yeah, I agree with that 1,000%. It's being recorded. I may get fired as the head of the Immigration Lawyers Association for saying this, but having talked to some people in the healthcare field, I'm pretty sure that doctors wish they could redo the last 10 years of just being completely oppositional to the role of nurse practitioners. And that's now a reality in practice. And I think so certainly the immigration bar, the legal community as a whole, I think needs to understand the importance of creating a holistic legal delivery service system that understands the roles that different people can play and where those appropriate dividing lines are between all of that. And to think about the use of technology in delivering those services. The legal community is notoriously behind the curve on a lot of those legal issues. And I think it feels to me that we really have to get out front of those issues. I mean, to follow the healthcare analogy, we are stuck in the emergency room and we are not thinking about how do we do healthcare delivery. And that's more true in the immigration context than I think in lots of other places, maybe because I don't know any other place than immigration. But it does feel to me that we got to get out of that emergency room environment and think about stepping back and thinking about how do we do this? Who are all the players that are at the table? How do we talk to each other and develop an ecosystem? Because I get the sense that there is plenty of business and need and opportunity to go around. So I certainly would invite any of you who are part of those conversations to include Ayla in that. We want to be part of figuring that ecosystem out. Yeah. Last question.
Thanks, Ben. Suzanne inspired me to talk a little bit about the need for legal defense funds because there is a tremendous appetite, I think, amongst private individuals to assist, and we've seen sort of like at clinic, we've seen folks set up GoFundMe pages and do things to raise funds, but thinking about that more sustainably and thinking more in terms of the movement that you've talked about, Ben, at the state and local level, advocating for legal defense funds. There's a lot that can be done there. This year, all 50 states will be in legislative session, and we're seeing a tremendous demand for our resources at Clinic on state and local initiatives that people can join into. I mean, again, people who have no immigration background or whatever, so we're trying to make resources accessible to individuals. And one of the things that we will be releasing a new resource on is legal defense funds and how people can work with their municipalities, their state and local government to advocate for those funds. Also, don't forget that someone mentioned TPS, I think, in one of the previous panels, that with this tremendous undocumented population growing by, the reduction of legal immigration, there will be specific nationalities who will be impacted by these policies. So we are also advocating that the foreign governments themselves establish legal defense funds for individuals who will be thrown into the system. And so that's one of our platforms as well. And so that's, I think, again, it's about thinking about the movement and getting people involved. At the state and local level, being able to have the tools to articulate and promote those types of policies are really important. You can look for Clinic to have resources like that. And I know that many of the organizations here have similar resources.
I mean, and part of designing the program that I'm building at Villanova, it's really interesting because I'm hearing from retirees. I'm hearing from people who are not already embedded in the immigration system, people like Susanna who want to do something, but they don't know what to do. And that's part of what's motivating me to think about how to create an online educational program to figure out what are the things that people need to know about immigration so that they can be helpful. And then how can I connect them in the community with the places where there are needs? So I really, again, I want to be involved in that conversation with Ben and others on, how do we think about the ecosystem and the ways that we can create different layers, if we can, in that system, and what are some of the pain points that maybe people like a volunteer retiree might be able to do so that they can drive people to a lawyer's office or whatever it is that needs to be done.
And I do just want to add, Suzanne, it's my understanding, at least, and correct me if I'm wrong, but that some of the defense funds that are now state and locally funded did start in a similar way that your organization has started. I'm thinking specifically of one in Miami that I believe was started by just a private citizen. And I could certainly get more information about that to you because I think that would be a fantastic idea for those folks around the country that are doing similar work to connect.
So yeah, I mean, I think that even setting up the New York system initially, it wasn't clear that what we should have is a public defender style system. One of the things we considered is sort of like sticky vouchers that people could take to attorneys. And one of the reasons why that ended up not being the way to go is there was a lot of concerns about the quality of the attorneys based on a study that we did with immigration judges. So I think all of this is just to say that one way that a lot of people can contribute is by doing sort of place-specific studies to figure out what the landscape looks like, who are the attorneys that they'd be going to, and you have a list of trusted attorneys, which is great. But I think kind of figuring out what the existing resources are and how to deploy those most efficiently is a good way to figure out what the right move is for each place, but also to convince other people that they should be joining in and adding resources.
Right. And I just wanted to follow up both on something Michele said and something that Ben said in terms of both technology and this sort of healthcare system analogy. I mean, I think that, at Clinic, working with Catholic charities across the country and other small nonprofits, in many ways, those are the sort of nurse practitioners, and they might be the ones who are sort of diagnosing the problem when the person comes in to naturalize, and the rep realizes that the person already has an in absentia removal order. And we do, I think, very effectively use technology to train people to become partially accredited BIA reps. But I do also think, in this time with so many more people being put into the immigration court system, that the need for actual fully accredited reps, attorneys, and et cetera, everything we've been talking about is just greater than it's ever been.
Okay, I think our time is up. John avoided giving me the hook completely, but thank you all very much for a great panel, and thank you for the great questions.